I forget. Okay, so any questions before we get started with this? You saw, or I hope you're keeping track. So we're busy with the general principles of contract, right? And under the general principles of contract, we are looking at week 4 now. And you will see as it progresses, I think it becomes a bit more and more difficult, you know, as we progress through the course. And it might be, and I'm just saying this, it might be that instead of only 6 weeks, I ask our other lecturer if I can take an additional week, maybe, in case where there's questions, where we have to unpack things a little bit more. Right. But basically this week, and good morning to everyone else who's joining. So basically this week, we're going to talk about intention and lawfulness, and then focus on capacity, right? And then you'll see next week, we look at agreements, the offer and acceptance. We look at possibility of performance and a few of those other aspects. And then that following week is then breach of contract and the remedies when someone breaches contract, right? All right, no, thank you. I've got a question here about pre-recorded. I will have a look on the materials that we uploaded. I think there is some pre-recordings there. And let me just, while I am here now, just go have a look. So under section B, general principles of contract, you will see there's week 3 materials, week 4 materials, week 5 materials, and then I've got the slide and voice, the pre-recordings of formalities, essential elements, void, voidable, lawfulness. Now it seems all of that is there. Let me just go back and just double check something else. And I've uploaded last week's recording. Yes. So, yes, with regard to that question, I've uploaded, remember last week, Tuesday, we didn't have a session, but we have then, I uploaded the recording from the Monday. So that will be up for week 3. And then basically at the end of today, I will upload week 4 recording. So you will have a Zoom consult recording as well for each one of the weeks. Okay. All right. So I hope that all of you, and good morning to everyone else who's joined us. I think a Tuesday morning is quite a busy class. That is wonderful. Yes. Okay. So what did I want to say? The Tuesday. Okay. So with regard to the test, I will upload the instructions or the content for the test, but just some of you have asked. Yes, the test covers section A. So section A was the introduction to SA law, right? So there will be a few questions on the introduction to SA law. And then as well, it will cover week 3 and week 4. So basically for every test, we try to cover 4 weeks of work per test, right? Remember, the test is still on the 7th of September. Next week, once the test is finalized, and so then we can negotiate and see if there's any clashes on the 7th, maybe move that test to the 8th or so. But I will upload a poll or a thing there, and I will speak to the class reps on that as well. Okay. The test covers then week 1, 2, 3, and 4. It is 30 marks for 1 hour. It's got 15 or 20 MCQs, and then 15 or 10 short answer questions, right? So short answer up to 5 marks, nothing more than 5 marks for a question, right? And so one of the things that we might look at for short answer questions is this issue of capacity that we're going to talk about. Right, it's the issue of capacity. All right, so I think without further ado, and if there's any further questions, please send it through, but let us have a look at this. So I've shared the screen here for week 4, basically looking at capacity in terms of the textbook. And again, those of you who are working with the older textbook, just page through, you will see it's, I think, a few pages earlier, it's like 59 or so for capacity instead of 66. So it's around about the same place, and you can work on that. Right. Sorry, please excuse me. I see we are capacity. I wanted to start with this serious intention. Right, so I hope you can all see serious intention and talk about that first. Now, remember, we are saying what are the essential criteria or requirements for any kind of contract, right? So it is essential requirement for a contract that the people, let's say the parties who enter into that contract, must have the intention to enter into a contract. So what does that mean? The intention to enter into a contract means the intention to be bound. We call it serious intention, to be bound to the contract. Or what they mention there in Latin, it's called animus contrahendi, right? So basically what it says is a contract will only be valid if both parties had the intention to be bound to the contract. That means the intention that that contract can be forced upon them in terms of the law, right? So that they are liable in terms of that contract. It means that if they do not do what they said they would do, right? If they breach the contract, that the other party, the wronged party, can then take this contract to court and bring legal action against them, right? And we'll see the last week that I see you, we're going to look at breach of contract and the remedies. But the remedies, for example, would be that you can ask the court to enforce the contract, or you can ask the court to award damages, right? So if the person has, say, for example, burnt the car, destroyed the thing that he was selling, then you can ask for damages in some way. And there's all kinds of criteria when it comes to the remedies. Right. So with intention, I think that is what I want you to know. If we talk about intention, how does it fit in? The parties must have the intention to be bound to the contract. They must have the intention to be liable in terms of the contract. Now, I will go through a few of these slides just to see if there's anything specifically that I wanted to mention. We said the contract must be binding. The offer, it must be a firm offer. It says not merely a statement of willingness. So let's say you go to a bank and you show the bank, here's your financials, you want to apply for a business loan. And the bank says, in principle, we will negotiate or we will contract with you for a loan, right? In principle. That doesn't mean that they have now agreed. They said in principle, it depending on other factors. So first they're going to do a credit check. First they're going to check any other business loans, what's your financial situation, etc. So we say a statement of willingness to do business is not a contract. That is not an agreement, right? Now, this is, I think, quite interesting. When will you not have an offer, right? So, or not have a firm offer or an agreement, a meeting of minds. So we're talking about the intention. So any agreement, I'm going to call it now an agreement made in jest. So an agreement made jokingly, that will not constitute a contract. So we've all played the lotto, and we probably all told our friends, if I win the lotto, I'm going to give you half of what I win, right? That isn't an agreement. We are not now in writing, confirming that if I do win the lotto, you can take me to court and sue me for half of my winnings, right? That's an offer made in jest. The same with where they say any offer that shows or expresses gratitude. If you rescue someone's cat from a burning building and that person says, thank you so much, I don't know how to thank you, anything you want, please just let me know and I will, that kind of expression of gratitude, the court says no, that is not an intention to contract. It is not a serious intention to enter into an agreement. Offer made to open or facilitate negotiations as well. So all of these initial kind of steps to get the parties to talk, to get the parties to reach some kind of an agreement or so, that in itself is not the agreement or a contract. Right? Only when the terms of the agreement have been set, where the parties are clear what they are going to do and what they will get, then can you say there's the intention to be bound, that there is some kind of meeting of minds. Now, I want to show you, so with this, I've set out, and I said, agreements that do not have a serious intention, agreements that do not have what we call animus contraendi, would be, for example, family agreements. Agreements made between, I would even say, well, okay, let's say family members, brother and sister agreement. Brother says, if I get to the army, I will help you get into university. Right, things like that. So family agreements, the court says, no, this is not intention to do business. Social and collegial agreements, if you make an arrangement with your friend and you say, we will, I'll meet you tomorrow at 1 o'clock in Glenwood at this restaurant, meet me there at 1. If you don't pitch up, your friend won't take you to court and say, okay, because you had an agreement, there was a contract, that she's now claiming damages because you didn't pitch up at your agreed upon destination, right? And why? Because the court will say social arrangements. And so that does not show a serious intention to be legally bound. I also included the honor agreement. So by the way, everything that I'm saying now, you will see family agreements. There's a little discussion on family agreements, social agreements, a gentleman's agreement. You've probably heard that, right? Where two guys discuss something and they would shake on it, but it is not, it is simply a gentleman's agreement. It is not an agreement that must be enforced in law, right? So it is not binding, right? You might say, okay, well, there is a moral duty on a person to complete that gentleman's agreement, but it's definitely not a legal duty to complete. Okay. And I mentioned the agreement in principle, where a bank agrees in principle to loan you some money. However, there's other things that factor into this equation, and so that is not enforceable. You cannot say, oh, but you said it's an agreement in principle. And then I mentioned agreement where there are certain formalities that have to be reached before the agreement is concluded, that would also then affect the agreement. Right. I've given you some of that YouTube videos to watch. So please have a look at that. And I'm sure there's more videos even than that, that you can look at the issue specifically about the intention of the parties. Now, I wanted to just set aside just a moment there to talk about marketing. Now, you know that we are constantly being bombarded with marketing proposals, right? Those of you, well, all of you have Facebook, huh? Even I have Facebook, but all of you have Facebook, and you know that somewhere Facebook or Google, someone is listening to everything you say, right? Then if you talk about, oh, you want to go out for a holiday, you really need a break, you want to go to Thailand, suddenly they keep on popping up little Thailand adverts, right? Or if you say something about a car, you're looking for a new car, somewhere someone listens and suddenly you're getting all these different kind of vehicles popping up on your Facebook profile. Now, the question is, those kind of adverts, are those adverts offers, or what is the legal position of that? And the courts have said that marketing efforts by a company is not a contract. Marketing does not have the intention to finalize a contract. What does marketing do? Marketing is there to invite you, the consumer, to do business with that service provider or that factory or whatever, right? So it invites you to do business. It is not the contract. So we have, for example, we talk about pamphlets and brochures. If you pick up a pamphlet at a stand, right, that pamphlet is not a contract. It just invites you to call them or to go and see them and then reach an agreement on something that you want. The same with price lists, or where you have a catalog of all the different things. I recently bought, for example, that cement table that you leave outside, one of those outside tables, right? And they gave me a catalog of all the different cement things and corrugated iron things that they have for outside. Those catalogs, those price lists is just there to invite me to do business. Right? And the same with advertisements. And so with the advertisements, I know we say that a certain degree of puffery is allowed, right? So you would see ever since COVID, Handy Andy, Jik, Domestos, Toilet Duck, all of them now suddenly says kills 99.9% of all germs and viruses, right? That is just advertising. It's just to entice you to buy in on the idea. Okay, so when it comes to intention, what do I want? I want you to know, how does intention fit in with the contract, right? You must show that you are have a serious intention to be bound to the contract, a serious intention to be legally liable in terms of that contract. Right. Now, I think that would be more than sufficient in that aspect. Okay, let us move on to the next part. So the next part of lawfulness. Also, I think this is a very clear, well, it's supposedly a very clear understanding. You cannot contract with someone to do something unlawful, right? Lawfulness is a core requirement of a contract. You can only contract to do a lawful thing, something that has not been prohibited by the law, right? So lawfulness, we differentiate there between common law and statutory law, right? But let's first say lawfulness means that the terms of the agreement must be lawful. The terms of the agreement must be lawful. An unlawful agreement is void, right? The terms of the agreement must be lawful. Any unlawful agreement is void. Otherwise, the court, there where I say the sanctity of contract, the law, the courts allow you to contract just about anything you want, right? So you can contract anything you want. There isn't an issue there as long as what you are agreeing to is lawful, right? When it comes to the common law, for example, there we look at, or the courts look at public policy, right? So public policy to say whether this agreement should be allowed or not, right? So if you want to, for example, sell your daughter, right? You are going to decided you need money, you're going to sell your kids off, right? Public policy says that you cannot do that. You cannot sell someone in slavery, right? But yes, so that is the issue of lawfulness. And I mean, it's again very short, 17 slides here. Let's just see if there's anything specific. Oh, the issue of public policy, I said that is a standard that develops over time. Right, so public policy is something that changes. As society changes, it changes as well. Take, for example, the issue of, what can we say, of cannabis. 10 years ago, it was unlawful to enter into an agreement to sell or to buy cannabis. Now, public policy has changed, and certain places, or if it's registered or what, I don't know, I don't buy it, but that they can enter into agreements of sale, buy and sell goods and products, and so related to cannabis. So we say general rule says all agreements are lawful unless they are prohibited by either statute, so legislation, or the common law, the public policy. And we say, for example, a contract will be unlawful if the making of the agreement is illegal, right? So, for example, a drug deal, selling an unregistered firearm. If the contract provides for performance which is unlawful, right? I said, for example, where you get pay someone 10,000 Rand to murder your business rival, right? To rob a bank. Where there's a common purpose, for example, X agrees to sell a gun to Y, knowing that Y wants to rob a bank. Right? So under all of these, an unlawful agreement is void, right? So unlawful agreement is void. So when we look at the common law and we look at public policy, we would say an agreement is illegal and void under common law if it offends against public policy. So if it goes against public policy, that agreement will be void, right? Sorry. And there, I said it is changing. For example, cannabis, smoking cannabis, I don't know, prostitution, if that hasn't been legalized as yet, but you can see in the next 10 years, it's probably going to be legalized and regulated or something like that. Right. So public policy changes, and it changes, the politicians change it when it comes to legislation, parliament, or any of those laws, right? Okay. Then I want to say, you can have a look, read through, because you do read through the slides on your own as well. The issue of statute, agreements which are prohibited by statute, those are regulated by some or other form of legislation, right? And when it comes to those agreements, those are not always unlawful. They might require that a minister or a regulatory body or someone gives permission, right? For example, you will see here a sale of foreign currency without treasury permission, right? So when you sell foreign currency or you bank foreign currency, you must have the permission from treasury to have that money. And that is one of the issues that they're going to ask President Ramaphosa, the $600,000, how long did he have that? Where did he get it from? Who paid from it? Who is this mysterious buyer from Dubai who pays $600,000 for a bull or a cow or whatever it was, right? So those kind of agreements, we say that the court will consider on a case-by-case basis. The court will see what is the requirement, right? So the court says, are there criminal sanctions created in that legislation? So is a crime created in that legislation that deals with this matter, right? And the court says, if it is a crime, will it link to the purpose of the legislation, and what would the effect be, whether greater hardship would follow by voiding the agreement versus if it left it legal. So when it comes to a statutory provision, the court then decides whether it is necessary for the contract to be set aside or not, right? All right, so all of this, you can have a look at blah, 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 as I say, contract law, and that just lawfulness. What do I want you to know? That the agreement must be lawful. It must be, the provisions must be lawful. It mustn't have any kind of illegal aspect to it, right? For the contract to be enforced. Imagine if you bought, what are those uncut diamonds, blood diamonds? If you bought blood diamonds and you paid 10,000 Rand for it, and now the guy doesn't deliver, and you want to go to court and force or ask the court to force him to deliver those illegal diamonds, right? So these are unlawful contract, or a contract with an unlawful purpose or so, is definitely not covered in terms of the law of contract. Absolutely not. Right. So for me, intention and lawfulness is quite easy to understand, those two concepts, and I hope you agree with me. Then the one that we have to focus on is this issue of capacity, right? And you will see that I've set out 3 slides of capacity. We start with the first one. This slide is, of course, only 19 pages, but looks at capacity. What does that mean? Capacity means the ability of a person to understand that he is entering into a contract and to appreciate what that means, right? So it requires someone with maturity. It requires someone to think about what they are doing and to know what they are doing, right? So let's have a look at this. For capacity, I would say that generally everyone has contractual capacity. So everyone means all natural or juristic persons will have the ability to contract, right? Because everyone has rights and duties. Everyone has that ability to understand, or the ability to incur liability, right? But these can be limited. So your contractual capacity can be limited. Surely you are not going to contract with a 3-year-old baby, right? Oh, child, a 3-year-old, right? And surely you cannot contract with someone who is mentally ill in an asylum, in a mental institution, So what we say, the capacity to contract, everyone in general, a juristic and a natural person, has complete and unrestricted control to enter into contracts. But there are always exceptions. Now, let's first look at juristic person. What is a juristic person? Is a company, a close corporation, maybe a business trust that is created by way of legislation. There's legislation that deals with companies, how it should be regulated, etc. Okay. So what would affect a company, a juristic person's capacity to enter into contract? And the first thing is self-imposed limitations. So a self-imposed limitation for a juristic company means, in terms of the memorandum of incorporation which establishes that company, the MOI will set out what the company does, what business the company has, what the company directors can and cannot do. Is this a financial institution? Will they invest? Will they produce, right? So the first, where we say self-imposed, is where a company itself, in the founding documents of that company, limits its capacity to enter into contracts. So that is the first one. The second one with companies is this issue of insolvency, right? So this we will actually only deal next year when, if any of you do the business enterprises law, we will look at companies, and we will look at specifically with companies, the winding up of a company and business rescue proceedings. So what that means is, if a company's liabilities exceed their assets and they cannot pay, right, they can apply for liquidation. So liquidation is a form of insolvency, and this means as soon as a company is liquidated, as soon as a company is declared insolvent, it ceases to exist. So immediately it cannot enter into any other contracts. It is gone. A trustee is appointed that sells off all the assets, and it is the end of that company. Right. So a juristic person can limit its contractual capacity either by its own self-imposed memorandum of incorporation founding documents, or it can be limited where it is declared insolvent, right? Where there is a where it has been liquidated, right? All right, so that with the insolvency. Now, juristic persons, so the next one is natural persons. And I said under natural persons, you can either have full capacity to contract, limited capacity to contract, or no capacity to contract. So full capacity, limited capacity, or no capacity to contract. What does that mean? Remember, we said that a natural person is a person like you and I, right? Is a person that was born, that has a mother and father, right? Now, I told the other group, one of the short answer questions that I would ask is identify and explain the factors, identify and explain the factors that influence or limits the contractual capacity of a natural person. Identify and explain, and let's see, because there's so many, we would say two. Identify and explain two factors that limits the contractual capacity of a natural person, right? And so you will then say, well, you're going to discuss mental illness, sorry, and you're going to discuss insolvency. And then you have to say, under mental illness, what do you understand? Under insolvency, what do you understand? Right. And I've set out each one of those, a discussion for mental illness, discussion for intoxication, discussion for criminal conviction, insolvency, marriage. And what is this last one that is hidden here? Prodigality as well. So let me just touch on these. Mental illness, right? How does mental illness affect your capacity? Surely if a court has declared you to be mentally ill, we don't want to say insane, right? But mentally ill or under a mental disorder, then you have, then you do not have the capacity to enter into contracts, right? So a person who has been declared to be mentally unsound, any contracts which they enter into will be void if they could not appreciate and understand the nature of it. If they could not appreciate and understand. And that is important because you'll see here, there was a case, Prinsloo versus Crawford and Prinsloo, where Mr. Prinsloo was declared mentally ill, right, and put in a mental asylum or a mental institution. Right. Mr. Prinsloo received medication, and so he had good days where he was perfectly fine, and then he had bad days where he didn't know who he was, etc. And during one of the good days, he met up, and I assume it was a nurse, because who would you meet? But he met this Miss Crawford, and he got married to Miss Crawford. Right. And so they challenged this to say that surely a person who is mentally ill, and the court says, no, if you can prove that he had a clear day, what they call a moment of lucidity, that contract, that marriage contract will be valid. Yes. So that was a very strange case. But so in general, if we say mental illness, a person who has been declared mentally ill will not have contractual capacity. Someone else will have to arrange his affairs on his behalf. Intoxication. If you are so drunk, right? If you are so intoxicated that you do not know that you enter into a contract, that you do not know even who this other person is or what you were supposed to do, and how does it work? The next morning you wake up and you're married to someone who you don't remember. You had a complete blackout. You don't know what is going on, right? That would also affect your capacity to enter into contract. So that would also mean that the contract will be void if a person was so intoxicated that he could not remember. Right? Prodigality is something that we don't hear very often. A prodigal, or what they really called is a spendthrift, a person who recklessly squanders all his assets. So something went wrong, right? He's not mentally ill, but he has some kind of emotional breakdown or mental breakdown or something, and he just starts to sell off all the assets, everything, right? Leaving his dependents destitute. So he has a wife and children, but every time they see, oh, there, the TV's gone, the couch is gone, this is gone, one thing after the other, he's just selling off everything, right? We say, the dependents can approach the court and ask the court to appoint someone, a curator, on this person's behalf to manage his financial affairs. As soon as the court, if the court agrees and the court appoints a curator there, then it means that that person, the prodigal, will not be able to enter into contracts, right? So then his contracts will be restricted, and he has to get permission from the curator, etc. Right? So this could also affect your capacity to enter into contracts. Insolvency, where a person is declared insolvent, Also, a trustee is appointed for that insolvent estate. You cannot touch any of your assets. The assets are taken over by the trustee. The trustee sells them off. So you have limited contractual capacity. You have no capacity over your own estate assets. Right? And the same with criminal conviction. If you've been convicted of a criminal offense where there was a dishonesty or theft or fraud or some issue of trust involved, you cannot be appointed as a director of a company, right? So your capacity to stand as a director of a company is affected. Alien enemy I've included there, but honestly, I don't know if any of you know what an alien enemy is, right? The alien enemy means if your country, if South Africa is at war with another country, let's say we are at war with Botswana, right? Then it means that all contracts that were entered into between a South African company and a Botswana company, those those become void, right? You cannot enter into contracts with a warring nation. Someone in the Ukraine cannot enter into contract with a company in, in Russia. So that is because it's seen as an alien enemy. We say all contracts entered into with any person who is living or carrying on business in enemy territory are prohibited. Right. Well, that is just one of those weird things. But I mean, when last were we at war with another country? This one, I think, let us just pause there. The issue of marriage, right? Before 1984, it meant that if a man and woman, husband and wife, get married, the wife is subservient to her husband and the husband has the marital power. Sorry. So it says prior to November 1984, when they marry in community of property, the marital power vests with the husband, right? The husband is the sole administrator of the estate, and the husband would decide what to spend the money on and what not. It meant that the wife could not enter into any contracts without the permission of her husband. Now, fortunately, the Matrimonial Property Act that we currently have has disbanded that, has said that the wife is not subservient to the husband. They are now on equal footing. They have a similar legal position, right? And this means that the wife can now contract without a husband's permission. Right? And especially where you have an in-community of property. I've set out the marital regime, so I don't know if you've ever wondered. If you get married, normally it would be in community of property. If you have a prenup, right, and you get married out of community of property, it's usually with accrual. Without accrual means that whatever increase in the estate will not be taken into account when it dissolves. And then with accrual, you will see is they look at what is the difference in the growth, and then they split that up. But so remember, with side number one, you have to be able to identify and explain at least two factors that will affect a natural person's capacity to contract. Right. So that is the first part of capacity. The second part looks specifically, part 2 and 3, at this issue of minority. How does minority affect your capacity to enter into contract? Right. Now, what is minority? Minority means an unmarried natural person under the age of 18 years is called a minor, right? So an unmarried natural person under the age of 18 years is called a minor. Here we make provision for two different sets. Firstly, a minor under 7 years old has no contractual capacity. Then we have a minor from 7 to 18 years old has limited contractual capacity. Right. So let's first see. A minor under 7 years old, what do we have? We say no contractual capacity, cannot understand or comprehend the importance of this contract. A 3-year-old, a 4-year-old, a 5-year-old, won't be able to understand what a contract is. A guardian enters into contract on behalf of the infants. So in this case, a guardian will enter into the contract on behalf of the infant. And who is the guardian? Is the parents, the mother or the father. Or if it's an unmarried mother, a single mom, then the mom, right? So that is a minor, a child, a baby, whatever you want to call it. In Latin, they say infants, child under 7 years old, no contractual capacity. Everything must be done by the parents, by the guardians. Right? Between over 7, but below 18. So up to before 18. Right? The other children, teenagers, have limited contractual capacity. Why? Because they've developed a little bit more, they understand a bit more, right? So we say the contractual capacity of minors over 7 but below 18 and who is still unmarried, right? They have limited contractual capacity. What does that mean? They can enter into contracts, but they require a guardian's assistance to enter into the contract and requires the guardian's assistance to dispute or defend a contract in the courts. Right. So the law recognizes that, yes, they have developed a bit more, but they still need assistance in some way. So you can have a look at that. I mentioned then as well, and this we discuss in the next slide, until when will a person remain a minor? Now, I assume all of you are majors or what we would call adults, right? Means all of you have at least attained the age of 18 and you are now at university, you are 18 years old, you do not need your parents' consent. So if someone if someone gets you to sign a virgin active contract, sorry, that is, you are now an adult, you can enter into a contract, even if it binds you for 2 years. Sorry about that. I don't know what happened. So you stay a minor until you reach 18, unless, so we say on achieving the age of 18 years or on marriage or with emancipation, right? So emancipation means where your guardian, your parents have allowed you to become financially independent, where your guardians, your parents have allowed you to get a job at age 16, to start paying towards board and lodging and rent and food. Even though you're staying at your parents' place, you are paying towards that. That means you are emancipated, which means that you do not require your parents' consent. You are seen by the law as an adult, right? Even though you are not 18 years old yet. Okay. I see the recording is going on. I just hope everything would be fine there. Okay, and then lastly with the minors, remember if we say a minor between 7 and 18 years old needs the parents' consent or permission to enter into contract. If the minor enter into a contract without assistance, it means that that contract is invalid, right? They are void. Right, so you can have a look at that nice case, Edelstein versus Edelstein, right? Also, we say, what happens where a parent enters into a contract on behalf of the minor child, but the contract is to the disadvantage of the child? The child is actually suffering as a result of that contract. It means that when the minor reaches 18, the minor can go to the court, or this young adult can go to court and ask the court to set aside that contract, right? And the court will then set it aside and order the other party to give back everything that he has received, and vice versa, right? So have a look at this. I think that is quite interesting. If the parents had acted on behalf of the minors and it was to their prejudice in some or other way. Okay, so when can a minor enter into a contract? Remember, they have limited contractual capacity. Number one, with the assistance of their guardian. They will be bound to contracts if the guardian had assisted them in the contract, or if the guardian had given some permission. Secondly, persons under the age of 18 years, we say, as soon as you are married, then yes, you will be allowed to enter into contracts, right? Remember, if a person gets married under 18 years, the parents have to consent and the Minister of Home Affairs have to consent to that marriage, right? I mentioned about emancipation. There is, for example, where a child, a minor, will have a separate residence and financial independence from his parents, where the parents allow him to open his own bank account, allows him to run his own business, right? That would mean he's been emancipated. And you can have a look at that case then as well. Okay. And then lastly, a minor can also enter into a contract if it has been ratified. Ratification means that the parents have afterwards given approval for that minor to be bound in that contract, right? So even though the parents weren't there initially to approve the contract, later on the parents approved and ratified. It means approving it, after the fact. And that would mean that the minor is legally bound to that contract. Okay. So when it comes to capacity, remember that you either have full capacity, that's your default setting, or you can have limited capacity, or you can have no capacity to enter into a contract, right? So some people will have no capacity because of mental illness, because of insolvency, because they have been declared a spendthrift or a prodigal, right? Or you can have limited capacity, for example, a minor over 7 or between 7 and 18 years old, a minor will have limited capacity in that sense, right? But still needs the parents' consent. Okay, and I think that is that. The last thing that I just said, just for interest sake, the Children's Act says that a child over the age of 12 can consent to a medical procedure without the parents' permission, right? The same with the Choice on Termination of Pregnancy Act, says that a girl child can go to a doctor and ask for an abortion even without the parents' consent, right, of any age here. National Road Traffic Act says for 17 years old to apply for a learner driver's license, and the Wills Act says 16 years to make a valid will. So there's always exceptions to the rule, but we say in general, you do not have the capacity to enter into a contract until you are at least 18 years old, right? Then you will have full capacity. Anything else might be limited capacity or no capacity at all. All right. I have stopped that share. So I hope that this helps. I hope that this clears up some of the slides. Please have a look at the slides again. And as I said, have a look at your slides for next week. Set aside the 2 hours, right, to look at offer and acceptance and possibility of performance, etc., so that you have some idea as to what we will discuss then next week. All right. And I am, in the meantime, working on that test. And as soon as we finalize the test, we will set out the content and the scope of the test. Right. But you know now, you can start. You already know the test is going to cover week 1, 2, 3, and 4 work. All right. Okay. Any questions from your side? We have another session at 2 o'clock or 10 past 2 if you want to attend that. If maybe there's some questions that you have, you are welcome to do that. Otherwise, I will see you again next week. Okay. Thank you. Yes. Okay. Thank you very much. All right. Okay. Let me stop the recording.